thank you for your patience. We begin now. Myself, Lav Kumar Kalyan. I am working as an associate in Vibgyor Marvels, and I welcome you all to the Vibgyor Marvels Capacity Building Session 2. The topic of today's session is a legal perspective on project management. Today's session will be presented by Mr. Kapil Gupta, an advocate and managing partner of law firm Kapil Gupta and Associates, and has been in practice for more than 14 years and spearheads the firm practice in the fields of litigation and arbitration, corporate and commercial law, mediation and alternate dispute resolution. He is also associated with Vibgyor Marvels as a legal advisor. The purpose of today's session is to provide a comprehensive view of the legal aspects of a project and to share practical on-the-ground strategies to the clients and contractor to negotiate possible challenges from project procurement to delivery. Please put up your questions or queries in the chat box as the session proceeds. Time permitting, we will take your questions or queries at the end of the presentation. Now I would like Kapil sir to proceed and take the lead.
Thank you, Love. Thank you, Love, for such an elaborate introduction of mine. Good evening, everyone. As Mr. Love has rightly pointed out, we are here to have a discussion on the legal aspects of how to manage the projects which are there going on in our country or abroad. So I am Kapil Gupta. I am a practicing advocate from last 14 years, and I provide a host of services to my clients across the globe. Let it be corporate litigation, arbitrations, corporate restructuring, insolvency, labor-related, intellectual property-related, joint ventures, infrastructure, information technology, etc., etc. I represent various business houses, not only within India, but internationally as well. And my main area of focus is to provide speedy remedy to my clients and to provide the best solution possible in the given scenario. I am associated with Vibgyor Marvels as legal advisor to provide its channel partners with strategic legal counsel to expand and establish their business in new territories. Amongst the other services which I provide for Vibgyor Marvels is to help their channel partners and Vibgyor Marvels for submitting the bids, forming the tenders, in their arbitrations, reviewing their claims, and dispute resolution mechanism. Now, in this aspect, the topic for today's discussion is a legal perspective on project management. So, for starting that, I would request Mr. Love to kindly start with the slides.
Love, can you record this session, please?
Yes, ma'am.
So till the time Mr. Love starts with the slides, what is the legal perspective of project management? What is a project management? Project management is when two or more parties, let it be private individuals, let it be government and private, or let it be government to government. Whenever a work is to be carried out, two people join hands. One is the person who gives the project, and the other person is who implements the project. So for implementing and for getting the work done, there are certain terms and conditions which are agreed upon between the parties. So there are basically various types of projects which are done. And let's start with the kinds of projects which are there. Mr. Love, can you, yes. So there are basically three kinds of projects which are there. One is the private projects, that is based on negotiations between two individuals or two companies. The next is the government projects. Government projects are basically between the government entities or government and private entities. These are generally based on two criteria. First criteria is that the person who bids the lowest, and the second criteria is if the project is of some quality which requires extraordinary knowledge, then in that eventualities, government projects are based on these two modes. The third is the international projects. International projects, again, like government projects, are based on either lowest bidder or on the quality. Love, can we shift to the next slide, please? So the private projects. Private projects are the kind of projects, as you can read, is between the client and the contractors are the private entities. These contracts are basically based upon negotiations depending upon the nature of work. The private contracts are most of the time determined as to who's in a better position to negotiate. If the client is in a better position like Ambani's or Tata's, or you can say any big time or Fortune 500 companies, they always have an upper hand. So they are the ones who drive the negotiations on the project. Whereas if the contractor is a big company, again, taking into consideration like Ambani's, Tata's, Adani's, L&T's, so they are the persons who drive the projects as per their wishes. So the terms of the contracts are based upon the mutual discussions between the parties. Now, the projects, private projects, the things which are to be seen are the nature as to what is the project. If the project is of such a nature which requires specialized knowledge and huge funds, then parties negotiate accordingly. Next slide, please. Now the government projects. The government projects or the PSU projects are the projects which are awarded under the procurement manual guidelines. So there is a procurement manual guidelines being formulated by the government of India. And in terms of the procurement guidelines, there are two kinds of procurements being done. One is the consultancy and one is the non-consultancy services. Consultancy services are in the nature of overviewing services. The person in whose favor the contract is awarded, he has to oversee that the persons who are carrying out work at the site are doing their services or not. Or for example, architectural services. If a government is planning to execute a project and for which they require maps, drawings, for which they hire architects, and those are called consultancy services. Whereas the non-consultancy services include all other kind of services. For example, construction, for example, procurement of any articles in the government, procurement of stationery, procurement of utilities, procurement of furniture, those are all covered under non-consultancy services. Now, under these two procurement systems, the procurement has to be done on basis of three methods. First is the low cost selection method, which is the person, if supposedly if the government needs to procure stationery, for example, then they float the tender saying that this is their requirement of the stationery and this is the estimated cost which the government is looking at and the estimated quantity. So people bid for those for that tender, and whosoever quotes the lowest amount gets the tender. Now there is a proviso over here or an exception. The government says that for procuring a tender, you are not required to bid below the level wherein either the quality is compromised or you are not able to fulfill your procurement of fulfill your commitment towards the government. So those kind of tenders are generally rejected. But if the cost is reasonable and is the lowest, then the government awards tender to that person. The second procurement method is the quality and cost-based selection. So, for example, if the government is intending to procure a specialized equipment for which there is a quality minimum quality required. So for that, the government invites tender, and the evaluation of those tenders are done on basis of the quality. So in that, the evaluation is done basically primarily on the basis of quality. What kind of quality is being provided to them, and that can go up till 80%. So supposedly if a tender carries 100 marks and the evaluation is quality and cost-based selection, so quality for quality, they keep maximum 80% marks. And if a person who's qualifying much more, getting much more marks in the quality department and less marks in the cost department, so basis the formula, basis the total, the tender is awarded to that person. The last category of procurement method is the single source selection. Single source selection is very rare and it is only permissible in extreme situations. The extreme situations are that somebody has a monopoly over it, somebody has an exclusive patent over it. So it is only in those situations that the single source selection is permitted by the government. Mr. Love, can you please slide to the next? Yeah. So the third kind of projects are the international projects. The international projects are the projects which are generally being floated by international bodies like foreign governments, United Nations, its subsidiaries, World Bank, IMF, International Monetary Fund, Exim Bank, and other public funded organizations. Again, the criteria for selection in those kind of projects is either the least cost selection or the lowest bid selection. The person who gives the lowest bid, as is in the government projects. So in all the three kind of projects, what is to be considered from legal perspective? The consideration for legal perspective is whenever a contract or a tender or a EOI is being floated, then the person or both the parties should meticulously examine the various clauses, the roles and responsibilities being given therein, as it's already written in the slide. But what is that needs to be examined is the intention of the parties. So the terms and conditions, whatever are incorporated in the contract, the intention of the party should be clear. It should not be like that the intention of the party is in a mist or is flouted or is under cloud, and one is not able to understand what does that clause means or what are the consequences of those clauses. So it's always advisable for any party, let it be government, let it be private bodies, or let it be international bodies, to always have a legal counsel or a panel counsel to meticulously examine all the clauses and incorporate the intention behind those clauses. Until and unless that intention is clear, again the problem arises. Love, can we all shift to next slide, please? Yeah. So whenever a tender is floated, what is to be seen from the client perspective or from the contractor perspective? The problems which I have seen from the client perspective is that they pick up the existing or a format which is already there in existence and just delete the requirements and just put it for bidding. The problems needs to be taken to the root level, because all these government organization or entities have councils, and they generally do not take advice of the councils while floating the tender, which is a big time problem. And I have seen and I have handled those kind of cases wherein, because of the problems in the tender document, the tenders have been cancelled by the courts. There were numerous corrigendums which had to be issued by the authorities, by the client, to clarify the situation, which does not give a good image, or which is not good for any organization. It shows that they were either kind of lazy, or were not kind of looking meticulously on the terms of the tender. However, once the tender comes out, then the parties who are interested in going ahead with tender should always review it from each and every angle. And I have seen situations wherein people have overlooked the various qualifications, prerequisites, and in turn have led to losing the tender. I'll give you an example. The example is, supposedly a person was required to submit an insolvency certificate in terms of the prerequisite of the tender. The person submitted the insolvency certificate, but the certificate was pre the date of the tender, post the date of the tender, whereas it was required pre the date of the tender, before the date of the tender. I'm just giving a hypothetical example. And when it came for technical evaluation before the standing tender committee, they rejected the tender. For such a small mistake, a tender worth crores of rupees goes to waste. The entire efforts being put are waste. So it's always advisable then that whenever a tender is being filled, or whenever a bid is to be submitted, one should look it at very thoroughly, and considering the fact that the huge amount and huge time is at stake. Therefore, they should always have a legal and technical persons in the same room while evaluating the tender. And it may take a little bit of time, but it's always advised to have the best foot forward while going for a tender. So once the tender is submitted, it requires now evaluation by the client. Can we have the next slide, please? No. Whenever a bid is submitted, the person or the bidder, and in the case contractor, should always have his technical and legal representative available for each and every stage of the evaluation. Why is it necessary? It's necessary because at times, whenever the technical evaluation is there may be certain things which are missed by the tendering authority, by the client, and they tend to reject your tender on those small technicalities which can be clarified at that point of time. So it's always advisable to have your legal and technical persons both available whenever the bids are under scrutiny. Let it be technical evaluation stage or the opening of the financial. Saying so, even if you meet all the criteria and you are being rejected by the bidding authority, either during the technical or financial evaluation or while declaring the results, and you believe there are reasonable grounds for challenging the said rejection, it's always advisable and in your best interest that do not wait for a single day. You should always approach your legal counsel and ask them that this is the problem I have faced, this is the reason they have rejected my tender, and it's wrong because of this reason. And it should be challenged immediately. The reason for saying so is that Supreme Court and High Courts of various states have now developed a consensus amongst them that tenders are such process containing so much of valuable time, valuable money, public money involved. So they don't interfere in this kind of process. And unless they find that the error is of egregious nature. What is egregious nature? The rejection is beyond the comprehension of a prudence of ordinary man. It's very harming or legally wrong. I'll say, for example, a person who applied for a bid, it's one of my cases. A person applied for a bid and his bid was rejected on the ground that he does not possess a X period of experience, whereas that person possessed. The certificate was also there, but it got missed by the evaluating authority. So when you challenge it and it is brought to the knowledge of the court that the evaluating authority missed that certificate which was already there on the ground, so that gives you a reasonable ground to challenge. But with each days of delay, how better your case is, how good your case is, it won't be looked into by the court. For example, there was a case which I was handling. In that case, the bid of the contractor was rejected wrongly, and he challenged it after 2 months. And the project had already been started. The work was in progress, and approximately 20-30% work was completed. The court said that no doubt there is a problem. Your bid was wrongly rejected, but still, since the work has progressed, therefore we will not intervene into it. We will not stay the tender, we will not cancel the tender because it's public money which is involved. Once a public money is involved, courts are very reluctant to intervene. So it's always advisable to challenge it up front and at the start itself. Love, can we have the next slide, please? Yes. Now, once the project is being awarded to a bidder who becomes a contractor, and the tendering authority becomes the client. So now it is a client-contractor relationship. Once a client awards a work, there are certain requisites, there are certain requisites which needs to be completed. For example, signing of a formal agreement. Tender itself is an agreement which contains detailed terms and conditions, but formal signing of the agreement is very important. So once that formal signing is being done, then in that eventuality, the work has to start. So once the work starts, there are very high chances that problem arises in the starting of the work at the initial level. So when the problem arises in the initial level, how does one tackle it? One tackle it by writing letters, by communicating with the client. For example, if I take an example, supposedly there is a construction project and the person has been awarded the contract or the tender to construct a building over a particular place. Now, when the contractor reaches that place, he finds that the land is encroached. There are persons sitting over here. So how does he start his work? He cannot start his work. So at that very moment, he should write letter to the client saying, sir, this is the problem I'm facing. The site is not free. It is encumbered. It is occupied by X person. So please provide me with the vacant land so that I can raise construction. But if despite writing letters, the objections are not the persons are not removed, the property is not made available to you, or the land is not made available to you, so in that eventuality you should always exercise your right for terminating the agreement, because it will otherwise cause you a lot of loss in terms of idle labor, idle machinery, idle staff, wastage of time. So it's always advisable to cancel the contract and initiate dispute resolution mechanism. Now, this is with regards to the projects which are done in India and is also applicable for international projects. But in international projects, there are other problems which are being faced. I was in a court and was overseeing a matter wherein I found that the work could not start and the disputes were raised only for the fact that in the international project, the visa of the expert was not granted. And the technical equipment which were required to be brought into the country were declined. So in such kind of situations, it's always advisable to examine all the possibilities which may arise or the difficulties which may arise at the time of filling the tender and take precautions accordingly. Otherwise, these kind of situations will only land up the client and the contractor in courts. So keeping in view these things in mind, it's always advisable whenever a contract is awarded and a client or a contractor faces any difficulty, then they should always communicate. And communication is a very important aspect, because tomorrow if dispute arises, then these letters, these communications helps a lot. If no communications are made, then it is deemed that the person who is suffering has no objection to his suffering. Then the onus and the responsibility is on that person to prove the kind of suffering he has done. And in the absence of any communication, it is not possible. So in such eventualities, I would always suggest that one should go for one should always communicate with the client and client vis-a-vis contractor. Can we have a next slide, please? So, like I just rightly said, that there are various defaults being committed by the clients on the part of the client as well as the contractor. So I'm just taking up the few examples of the client. If you can just read as well alongside me. Specifications were provided belatedly. No instructions or belated instructions were provided against the problem faced by contractor and brought to the knowledge of the client within reasonable times. Bills are not cleared on time. Permission for carrying out extra work is withheld for long. Payments against the extra work is declined. Handing over, taking over of the site is delayed. Contractor, sorry, is delayed. Now, what are the consequences? Consequences are contractor exhumes extra resources like payment of extra wages, labor, staff, equipment, idling, extended period. There is always scarcity of funds. If bills are not cleared, the contractor will always be short of funds and won't be able to perform the project in time. This also results in escalation in prices of material, loss of profit for extended period of work. Extra expenditure is charged by contractor to clients along with necessary bills documents. So it's always important that client should respond to the problem faced by the contractor, either by resolving the problem or justifying it or falsifying the hindrance alleged by the contractor. The reason for the same is that most of the times contractor, they are smart. So they always write letters to the client, but client does not respond, which always work against the client. The client should always put in their response this way or that way. Non-response to any letter of the contractor means that the client is accepting the gift. Now this applies vice versa also. Can we have the next slide, please? So now the contractors are also at fault. It's not always that the client is at fault. The defaults by the contractor are, they don't comply with the requirements of the tender. Supposedly they don't provide for the work chart, work program chart. They don't provide the day-to-day information as to the progress of the work. They don't deploy sufficient numbers of labor or staff. They deviate from the specifications without permission. And most of the times the work is never completed within time. So in such situations, the client always has a right to point out the breaches, and they should not let it go. That's by saying that you complete the project, we'll see it in the last. They should impose the penalty then and there. And for that, the latest example is being followed by Ministry of Roads and Highways. NHAI is doing that kind of work which is unexpectable. The kind of roads they are being built and the contractors are penalized for delay shows this is achievable. So it's a two-way system. If client and contractors work hand in hand, then these kind of problems does not arise. The problem arises only when the party who is at fault tries to pin it on the other. And the major reason for courts being overburdened are these only. They do not accept that they are making mistake. They try to pin it on the other, which is wrong. So in such eventualities, how do we go about it? We have no other option but to approach the court. For approaching the court, there is a mechanism. Love, can we have the next slide, please? So there is a mechanism, and the mechanism is generally provided in the agreement itself. If the agreement is silent, or the contract or the tender is silent as to the mechanism on which the disputes between the parties are to be resolved, then it has to mandatorily go to the court. But if the parties are smart and they don't want the problems or the disputes to hang on their head for long, so they choose a mechanism. The mechanism being chosen is generally the arbitration clause. And why arbitration clause? Because the recent amendment or the recent changes being made in the arbitration law is that whenever party chooses to resolve their dispute through arbitration, then that arbitration has to mandatorily, compulsorily finish within a period of 1 year with a upper limit of further 6 months, but with the permission of the parties. So this is now become the most efficient, fast measure to resolve a dispute. The another reason for making arbitration clause as the dispute resolution mechanism is, again, the changes being made in the law. The changes is whenever any dispute is being resolved through arbitration, that dispute is not to be intervened or interfered by the court in a regular manner. It is only when there is something very highly illegal, then only court intervenes into it. But the court cannot modify the order passed by the arbitrator. They can either set it aside or they can uphold it. So the courts are now very reluctant, keeping in view the international pressure, keeping in view the backlog which the court has. So this mechanism of dispute resolution is much more renowned, much more followed, and as on date, the best process to resolve the dispute between the parties. Love, can we have the next slide, please? Now, what is the arbitration mechanism? The arbitration mechanism is both the parties agree in the contract that any dispute between them shall be resolved through arbitration. And arbitration can be comprising of 3 persons or 3 members or 1 person who is the sole arbitrator. When it comes to 3 persons, in that eventuality, both the parties, client and contractor, appoint 1 member each from their side, and both the members then agree to appoint a 3rd person who is the leading arbitrator or the presiding arbitrator, or whom we say as an umpire. The decision of umpire, if there is a split between the member of the client and the member of the contractor, then the deciding authority is the umpire and can't be objected. Now, when we come to 1 member tribunal, which is also called as sole arbitrator, the sole arbitrator is the person who is mutually agreed upon by the parties. If the parties do not agree upon a name, then there cannot be an arbitrator. But for that, you have to file an application before the High Court, because the High Court under the law is the only authority for the domestic projects or within the country projects, and Supreme Court if it is an international project, to appoint an arbitrator if there is no consensus between the parties. Now, the general perception is that whenever you go to court, it takes time. So if you want to appoint an arbitrator, arbitration is a shorter process. But now getting an arbitrator appointed is again a lengthy process, because you have to approach the court. But that is not the scenario in the present day. The courts are very strict now. They only see the parties have agreed to get their dispute resolved through arbitration. And once they find that, yes, the parties had agreed, then they immediately appoint arbitrator. So it takes maximum 1 hearing, 2 hearings, or 3 hearings at best. So again saying, arbitration is the best mechanism for resolution of disputes. In fact, now the government of India has taken the initiative and has constituted a tribunal called AMRCD. What is AMRCD? AMRCD is a brainchild of the government of India, where the government of India says that in any dispute, parties are government entities, let it be state government, central ministry, or PSUs under state or PSUs under the center. They are not supposed to go to the court. They are not supposed to go into arbitration. Arbitration will be done internally, because ultimately it's the public money which is involved. So if it is the public money, why that money be spent in conducting arbitrations or going to court? The process under AMRCD is that the secretaries of the respective ministries are made to sit together to work out a solution between the parties. And if they agree to a solution, then it's fine and binding on both. In the eventuality they don't agree, then the chief secretary is involved. Chief secretary becomes the umpire. Both present their side or their scenarios before the chief secretary, and the chief secretary decides as to what is to be done. And his decision is final and binding. Though his decision is also challengeable before the court, but being the government of India enterprises, the government of India discourages it, and there is rare scenario when those have been challenged. And whenever those have been challenged, they have been decided within maximum 1 or 2 hearings. So I haven't seen a situation or such mechanism being done to save the public money. So this is the concept of arbitration. Now, irrespective of whether it's a 3-member arbitral tribunal or a sole arbitrator, once the dispute is referred to arbitration, how do we proceed? What is to be done from client's perspective and from contractor's perspective? In maximum number of times, it is the contractor who approaches or who press upon for formation of the arbitration tribunal. And why is it so? Because in the government contracts or the government tenders, the power to levy penalty is with the client. And whenever there is either default or no default, the government imposes penalty. Once the government imposes penalty and they deduct it from the contractor's due money, so it is the contractor who is at the losing end. So it is the contractor who approaches the tribunal and asks them to resolve the dispute. Now, before the arbitral tribunal, whenever any dispute is raised, in that eventuality, the party or the contractor should raise all their claims, irrespective of anything and everything, and should rely upon everything or all the documents which are there in their possession. I would suggest, amongst the other claims which the contractor can raise, it should raise the claims of arrears of their dues, interest, expenses being incurred by the contractor because the contract got extended, the idling charges towards labor, staff, machinery, escalation of labor charges, material prices, and the loss of profit. Now, they have to support it with the documents. What are those documents? The documents are the same documents which I referred initially. That immediately when the award, the tender is awarded and there are problems, one should communicate. And it is only basis of those communications that the person succeeds or loses in the arbitration. So this is my experience, my hands-on experience on the arbitration, the legal perspective on the project management. And thank you all for the patient hearing and giving me indulgence. Thank you. I'll hand over it now to Love. However, before that, I would like to thank you. I would like to thank Vibgyor Marvels, Mr. R.K. Gupta, Ms. Shakti Singhal, Mr. Love, and Mr. Devnath Shaw for giving me this opportunity. Thank you. Love, you can take it over from here.
Thank you, Kapil sir, for your detailed presentation. I can see few questions in the chat box, which I will now address to Kapil sir to respond. Sir, the question is, if a firm registered in India is executing a project outside India, say in Malawi in Africa, and it needs legal assistance to undo some wrong, unfair decisions or orders of the client, which is affecting the progress of the project and the business prospects of the Indian firm, can it use the services of Indian lawyer firm to take up the matter in Malawi? Or does it need to engage a local lawyer?
So thank you for the question. And it is a very interesting question. I have dealt with a similar situation wherein a client of mine was executing a work abroad, and there were technical difficulties which he was facing. So being Indian company, we understand the difficulties, and they can certainly approach us and we can take up the problem. But if it's in a foreign country, then yes, we need to also hire local lawyers over there, local counsels over there to for compliances. But ultimately, being Indian entity, it's always advisable to have a counsel who is of your country and who can understand the legal technicalities, because going abroad, you may engage a counsel directly as well. But understanding the situation over there, the legal technicalities is very difficult. So yes, I will advise always to have a counsel of your origin and a local counsel over there. Thank you.
Sir, the second question is, an Indian firm has been debarred from...
Love, wait, I want to extend the Kapil's reply that if you have a dispute in a foreign country, we must have an Indian lawyer to understand the Indian company's requirements and the challenges. But the local client is also required, particularly because of the language issues. Because in many countries, we have Spanish speaking or French speaking cases. So we must have lawyers who can speak and submit to the court the petitions in their local languages. So it requires a combination of an Indian lawyer and a foreign lawyer.
Thank you, sir.
If anyone has any questions, you can ask. You can unmute yourself and ask Kapil sir.
This is Arvind Kumar from Vibgyor. Thank you, Kapil Gupta ji, for a very wonderful session. You have elucidated the matter extremely well with lots of practical tips, and I'm sure the members of Vibgyor Marvels would find your session very useful in implementing various projects. I have a couple of questions.
Yes, sir.
Because sometimes arbitration panel awards are questioned in courts and they take a long time to settle. A practice of dispute resolution boards had been started in many countries, including in India. What, in your experience, has been the performance of DRBs in India so far?
Right. Thank you, sir. First of all, thanks for your patient attending the event and bearing with me. The second thing is that insofar as your question is concerned, so sir, dispute resolution board is again a mechanism which is to be decided by the parties while executing the contract. So it can be a part of it, but it is not a compulsory mechanism by which the disputes can be resolved. So what I understand is that the government entities or some private entities have now started incorporating a clause saying that if during the execution of a contract, there is some dispute or some problem or hindrance arise, they can refer it to the dispute resolution board and they will sort out the problem so that there is no hindrance in the project. So that mechanism is again a very good mechanism, but it is not so much prevalent. And I encourage that kind of dispute resolution mechanism. But again, it is not in vogue too much as of now.
Thank you, Kapilji. Second question is, it is often seen that during the execution of the projects, for small variations, the contracts are held up and the projects are delayed for years and years because financial settlement of the extra items for the scope variations could not be done in time. What do you think the strategy needs to be applied by both contractors and the client so that financial impact of such variations are settled as soon as possible to avoid an impasse or a legal dispute?
Right, sir. So in that aspect, whenever a project is awarded, neither the client nor the contractor wants to raise any dispute. But these are the ground situations which are there. So my advice has always been that clients and contractors should sit together and resolve those problems. If the client thinks that it cannot be resolved, then they should compensate the contractor accordingly. Likewise, contractor should also understand that whatever project they are executing, it is not 100% that they will be able to, that no problem will arise. So in such situation, it's always advisable to call for the meetings, to incorporate a provision in the tender so that whenever a dispute arises or whenever a hindrance arises, they can sit together and the meeting should be minuted so that tomorrow nobody can back out. And when the dispute resolution mechanism is initiated, these documents will come handy both to client as well as to contractor. But ultimately, it is between the parties. If they want to resolve it, they can resolve it amicably. Otherwise, courts are there to resolve it.
Okay. Thank you so much, Kapil. And
Thank you, sir.
my last question is that can you guide as well as alert your listeners about the type of legal lacunas that you come across in the tender documents, which you would like to inform us about?
Yes, sir. That is the biggest concern I have always had. And I had also stated some of the points, but I'm very glad you brought up that question. Sir, government companies have a set format. And whenever they float a tender, they use that format. They just make minor changes, tweaking here and there, deleting some clauses, adding some clauses, but they don't understand what is the soul and heart of the project. What are the problems which they face? They just use a set format and just float it. And this is where I have faced a problem. I'll tell you particularly in a tender relating to contract. A clause was inserted that the person has to provide the architectural drawings. And if he doesn't provide the architectural drawings, then a penalty will be levied on him. A contractor who's to only work on the guidelines of the client, where is the need of him providing an architectural drawing? He has to work on that architectural drawing. But people overlook, can't really help it out, sir. And this is why we are here to help them out, sir.
Thank you so much.
Thank you, sir.
नमस्कार कपिल जी।
नमस्कार सर।
सर प्रशांत गुप्ता सर, थैंक यू सर, आपने बहुत अच्छे से एक्सप्लेन किया सर। एंड थैंक यू आरके गुप्ता सर, थैंक यू विबग्योर सर। मेरा एक छोटा सा क्वेश्चन है सर कि सर व्हाट इज द बेसिक डिफरेंस इन बिटवीन कंसोर्टियम एंड जेवी?
Sir, basic difference between a consortium and a JV.
Yeah.
Consortium comprises of basically there is a how do I explain? Because there is a very thin line between a consortium and a JV, right? Joint venture is when two people join hands and they bid for a project, but in their individual names, projecting as a joint venture. Consortium is when again two or more people join hands, but they form a consortium, and that is like a front name under which they apply for a tender. So this is the basic difference between a consortium and joint venture. Joint venture, the agreement is not necessarily required. The terms can be vague, but consortium, there has to be an agreement between the parties, and if they are bidding on the basis of a consortium, then that consortium has to be a detailed consortium comprising all the detailed terms and conditions between the parties.
So, but for client perspective, when in tender में लिखा होता है कई बार कि consortium is allowed, कहीं लिखा होता है consortium oblique JV is allowed, कहीं लिखा होता है JV is allowed. So in consortium normally there's a practice कि हम लिख देते हैं कि यार A, B, C are in consortium and A is lead member and A will be doing all billings, he'll be responsible to take all payments. So sir, which is the right practice to do work from client side or from consultant or contractor side, that as from legal point of view, a JV should be formed with special purpose vehicle or a consortium practice is fine?
Sir, it depends upon the terms and conditions of the contract. First, according to what I understand is the clients or the contractors don't understand the concept of consortium or joint venture.
Right.
They just write it that consortium is allowed, and at times they write joint venture is not allowed.
Yes, sir.
That is something which is bizarre, because see, they follow a set pattern, and in that set pattern they fail to understand that both are one, more or less one. So from client perspective, I'll always request the client that you should, whenever you say joint venture or whenever you say consortium, you should always define what is a consortium and what is a joint venture. So if the definition is provided in the contract itself, then in that eventuality, there will be no chaos or no doubt. That would be my suggestion. Let it be client or a contractor. And if the contractor, sorry, sir.
Kapil, may I elaborate this, the reply?
Sir.
Mr. Prashant Gupta, thank you for participating. You are able to hear me?
Yes, sir. Yes, sir. Thank you, sir.
So, you have asked a question about JV and consortium.
Yes, sir.
JV, one which two people form or two or more people form and create a separate identity. They have to open a separate bank account in the name of the joint venture partners, and they have a work sharing agreement, and they are severally or individually responsible for executing the project.
Right.
In a consortium, you need not have a separate bank account, and you may not have strict work sharing, but the consortium is jointly responsible for delivering a project. A consortium is formed for qualifying criteria and also delivering the project. There, the concept of the lead partner is more applicable, but in the JV, there is no lead partner. Even a 5% shareholder is equally strong as a 95% JV partner. So for for PSUs and other companies, JV formation is almost impossible because it requires the approval of the President of India that they can go into a JV with somebody else. But yes, private companies can go in and form JVs, open separate bank accounts, but a JV is an independent company for all purposes for that particular project. Thank you.
And just in some projects in consortium, like there are 3 people in a consortium, and any of the consortium member can furnish performance bank guarantee to the client, or only lead member has to give?
That is not, that requirement can be fulfilled by all the three parties.
Any of
Jointly.
the three parties?
Any one or all the three.
Anyone or jointly by three, right, sir? That's it, sir. Thank you, sir.
Thank you.
Since we have already exceeded the time limit of this session, others who have questions, you can send the same to me via email and we will respond to you at earliest. Now I would like to thank
Love, before we conclude, I would also like to mention and address all our participants that the times of only having a project management consultant are over. Earlier, we used to have a contractor who used to work for a department. And in department, people used to change, the engineers used to change, and then there were a lot of problems. The quality control mechanisms were vague and loose. So the times came when every project has a project management consultant. The project management consultant takes care of the responsibility of quality control, costings, measurement, and then making the payments. But now I am advocating that it is the time for project techno-legal services, where engineers and lawyers come together to deliver a project on behalf of the government as well as the contractors. Because we don't want to end up in projects which take 10 years to deliver, and after 10 years they go for 20 years of legal disputes into arbitration, going to the high courts, supreme courts. So the day the project is over, we should have no legal disputes, no pending payments, nothing. That is in the interest of the government, the client, as well as the contractors. So more and more, we are telling our participants, our members, that we should have techno-legal consultancy, where we have a technocrat and a lawyer working together to deliver the projects. Thank you, Love.
Thank you, sir. Thank you, sir, for your explanation. Now I would like to thank Kapil sir for presenting this session. I would also like to convey my vote of thanks to the following person who are actively involved in the conception, formulation, and putting up together of this session. They are Mr. Rajinder Kumar Gupta, President, Vibgyor Marvels, Ms. Manisha Dhankar, Director, Vibgyor Marvels, Mr. Devnath Shaw, Associate, Vibgyor Marvels, and all those behind the scenes who are involved in putting up of this session. In the end, I would like to thank all our participants for their active participation. Have a good day ahead.